Okay, folks, welcome back this afternoon. We are going to get a first look at H-293, which is an act relating to health equity data reporting and registry disclosure requirements. And we have the General Counsel from the Department of Health, Lauren Lehman, here. And Lauren, welcome to House Human Services.
Thank you.
Happy to have you. The committee has not had a walkthrough of the bill yet, so what we're most interested in terms of testimony from the health department, we understood from Representative McGuire that this was a bill requested by the health department to do some sort of miscellaneous cleanup and language changes, and it'd be helpful to know, in general, what the reasons are for the necessary changes, and I'll turn the floor over to you.
Thank you so much. My name is Lauren Lehman. I'm General Counsel for the Department of Health. Thank you for the opportunity to walk through these proposals today. You're correct that these are some what we consider technical changes to existing statutes that just help us manage our work on a day-to-day basis. One is very simple and direct, and I apologize in advance. The other one is very detailed and complex for very little payoff. So a lot of background to help understand it, but it really ultimately does not change the underlying intent and purpose and effect of the bill. So I'll start with the easy ones and then do a little background on the registry ones. So for the health equity data changed, we're simply asking that we move from annually reporting to every 3 years, beginning in 2028. So we have annually, our Department of Health Statistics and Informatics compiles, we receive constantly and report out implications and impacts of health inequities and health disparities throughout the state, and we report those. We have an additional requirement to compile all the health inequities and disparities found in these various reports into one single report and report that. So it's in addition to already identifying health disparities in certain areas, we're then supposed to analyze those or compile those into one single report. And so we're asking that requires a lot of work and a lot of review in addition to the underlying reports that we're compiling. And so we're hoping to do that kind of compilation work every 3 years rather than annually. So that's the proposal there. Sections 2 and 3 of the bill regarding the registries are both similar requests. So I'm going to compile those into one discussion, if that's all right. I'm happy to answer questions on each section, but they relate to the cancer registry and the ALS registry that the state has. So when somebody's diagnosed with cancer in the state or ALS in the state, data regarding those patients is reported to the Department of Health. And the purpose of those registries is to compile data in one location to help identify public health implications and to share that data. We share it regularly. There's not a lot of other states with the ALS registry. With the cancer registry, there's a national registry with the Centers for Disease Control and Prevention. There's also registries in other states. So that information that is reported to registries is protected health information. It has case information from an individual patient who has been diagnosed, their treatment information, and other data points. Similarly, the Department of Health and the Agency of Human Services in general are covered entities. So we are subject to HIPAA, and we are subject to HIPAA specifically for the data that we receive for cancer registries and the ALS registries. That data is protected by HIPAA. Under the existing statute.
Lauren, just a second. I just want to make sure, does everybody understand what HIPAA means?
Oh, yeah.
Everybody know? Okay, I figured they did. It's been around for a while now, so I just wanted to make sure people understood the acronym. Thank you. Sorry.
Thank you. Yes, and if I use any acronyms that folks aren't familiar with, please stop me. I know that we are a bit of an alphabet soup. So we're subject to HIPAA. This data is protected health information, sometimes called PHI. And that means that it has, with limited exception, it cannot be redisclosed. Section 18 VSA 155 and 172 allow disclosure of this PHI for very limited circumstances and in compliance with HIPAA. So under existing law, the Department of Health can disclose cancer registry data to the Centers for Disease Control's National Breast and Cervical Cancer Early Detection Program, to other states' cancers registries, and the federal cancer control registries. If we have an agreement in writing that the recipient, so one of those three limited entities, has agreed to keep any information they receive confidential and privileged. So that's one element. We could also disclose to health researchers if they both have that agreement in writing and they have approval from an academic committee for the protection of human subjects that's established in accordance with federal regulations. Those committees are often called IRBs or institutional review boards. So if a researcher comes to VDH and wants that registry data for their public health research, they need to both sign an agreement saying that they will keep that information confidential, and they need to have approval from an institutional review board who's looked at their research study and has approved waiving an individual's right to authorize disclosure under HIPAA. And then VDH can take that assurance from the IRB, the institutional review board, plus the agreement. The IRB provides us with reassurance that this person's research study has been looked at, that the information will be safe and be used in an appropriate manner, and that it is appropriate to waive individuals' authorization. Then we can disclose that data. So that's how it's historically worked. That's also an exemption under HIPAA. So HIPAA also has that same allowance for disclosure of protected health information if there's IRB approval and if the researcher agrees to keep the data confidential. So
Lauren, quick question. So what is the difference between the Code of Federal Regulation that's being struck and the one that's being inserted?
Thank you. So that's where we get complicated. So that's what happened in 2017 was there was a change to the federal laws that excluded from the definition of research public health surveillance. So suddenly, researchers who are doing research for public health surveillance purposes can no longer get IRB approval because IRBs review research studies and public health surveillance is not research anymore. Well, a lot of folks coming to VDH for the cancer registry and ALS registry data are doing it for public health surveillance purposes. They're looking into clusters of cancer. They're looking into frequency of disease. They're doing public health surveillance. So they're stuck in a position now where they can't get IRB approval. So they can't meet the requirements of our law, and then they can't access the data. What HIPAA did to address this was create a secondary type of board that plays the same role as an IRB, but is not subject to that rule that excludes public health surveillance from the definition of research. That's called a privacy board. The privacy board has the same requirements as an IRB to look at the study, to make sure the protections are in place. So it plays the same role, and it can play that role for public health surveillance research as well as for other research projects. The Vermont law, the proposal here is to amend the Vermont law to allow approval by a privacy research or a privacy board as well as an IRB, so that if a research study is unable to get IRB approval because IRB won't offer it, they can go to a privacy board as defined in HIPAA and get that same approval.
And so it is, okay, my question is then, is 45 CFR Part 46 only related to IRBs?
Yes.
Okay, and then is 45 CFR, the rest of the section you have identified there, does that relate to IRBs and privacy boards?
Yes, it does.
Okay, so that was, I guess that answers my question, because I was wondering like why we would eliminate the first reference to the CFR, why wouldn't we just add the second to it? But if the second includes both of them, okay. Representative Donahue has a question.
Yes, thank you. I'm just wondering from this language, evidence of the approval. So the commissioner receiving this, it's kind of, if they've got the approval, that's it. There's no looking deeper into what the institutional review board approved or didn't approve, or how thorough their work was.
We don't, those IRBs are subject still to 45 CFR Part 46. So there's significant federal regulation of those IRBs and what they're supposed to look at. HIPAA also has specific requirements for the composition of IRBs as well as for privacy boards and what they're supposed to look at. So we, in the evidence we receive and look at, we don't do that review, but federal regulation is significant for those institutions.
So, yeah, just it's fairly recently, there was guess it was a reinterpretation, maybe some amendments. There's some huge loopholes in what IRBs are required to review. So I actually don't trust the fact that they simply have an IRB, depending on the state and what the state does or doesn't enforce or how they review it. There's some real problems. So I am always a little uncomfortable when I see us just automatically accepting the fact that an IRB approved it. I was actually on a national AHS advisory panel on the issue nationally. And so I have a fair amount of experience in this little subcategory of law around protection of patients of human subject research.
I really appreciate that insight. And I think it is, we defer really to the committee and to the legislature on whether it is sufficient to have these approvals. Our proposal is simply that if the requirement is still there to have, to allow disclosure of cancer registry data to researchers, that we include public health surveillance researchers as well by allowing approval by a privacy board. If the decision is made that the legislature doesn't want to disclose any of this data to researchers without an authorization from the individuals, I think that's a separate question that, we defer to you on.
Representative Steady and then Representative Cole.
Mine's just a grammatical thing because I'm weird about stuff like that. So like agencies or researchers assurances, you would basically have to have an asterisk after the researchers for the possessive form, or you'd have to change it to affirm, like an affirmation that is acceptable to the commissioner without the asterisk.
We'll talk to Katie about that.
Yeah, it's a possessive form. Yeah, Katie would know that. So it'd be researchers with an asterisk.
I'm not sure because I think it's just referring to the plural there, but Representative Cole.
Thank you, Lauren. I'm curious about some of the context with the 2017 change in federal law and maybe how that could inform the choice we make with this piece of legislation. Like, I completely agree. Public health information and data is very critical for getting the bigger picture of what's going on. But yeah, very curious about why that change was made. Was it strictly privacy reasons, maybe, and to, or Rep. Donahue knows more than I do, but.
Yeah, I'm much less familiar with the more recent changes.
Okay, yeah.
Yeah, it's a good question. I'm happy to look into it. I think the biggest distinction was that they didn't feel like surveillance was research. But I don't know for sure. And so I'm happy to go look back at the comments on those rule changes to see if I can dig up the purpose for excluding public health surveillance.
Thank you. Yeah, especially if there were certain cases where people feel like there were certain privacies that were violated, like I think we'd want to take that into account with this while maximizing our access to non-identifiable information. So thank you.
Of course.
One of my questions arises around, I'm not sure what is meant by assurances acceptable to the commissioner. And deleting the requirement to have something in writing. What, can you give us examples of what that would be?
Yeah, so this was written and this was written back in August of last year, September of last year. So things have shifted since then a little bit. But I do want to say, one of the challenges we've had is, the cancer registry data, part of its benefit is being able to exchange and use it different places. So folks can look at patterns, do research and figure out, if there's certain causality and association with different environmental and other factors. So we regularly would disclose information to the Centers for Disease Control as authorized under 152. The Centers for Disease Control it says an agreement in writing, and our Attorney General in our state has interpreted agreement in writing to mean a signed agreement. The Centers for Disease Control last year or the year before put out a written policy about what they would do with the data and assurances that they would keep it confidential, et cetera. And they insisted that that was a written agreement, and every other state was allowing disclosure based on that written agreement to keep the information confidential. Our state said, no, we need a signature. And so this change, this modification of with assurance would allow for the acceptance of a written policy assuring confidentiality. And it would be consistent with HIPAA as well.
Yeah. So I'm thinking that language that says more what you just said would be better than what's here in writing. Because I think that we're not really interested in giving up the in writing part. But it could be, written policy. It could be, we can figure out language to a deal with that. Or it could just be written assurances acceptable to the commissioner. But I think we're going to want to keep the in writing part.
Absolutely.
Okay, let's move on to the ALS one.
So the ALS, it's very similar to the cancer. It's the same explanation where we're trying to, if the decision is to allow disclosure of cancer or ALS registry information to researchers based on an IRB approval, that we also allow it for a privacy board approval.
Okay, I see the language is the same. And so I'm probably going to ask Ledge Counsel to help us with the citation that the new citation that you have and how that differs from the existing citation. I guess wanting to make sure that we're not inadvertently. I'm still wondering in my head about whether it should say both or not, I guess that's my question.
Sure.
So, but does anybody else have any other questions for Lauren regarding what the intent of this is? Okay, thank you, Lauren. You're welcome to stick around. We're going to have Katie here in just a moment. She's here, but we're going to ask her to move to the witness chair. Essentially, Katie, I think Lauren's just gone through the bill with us, so I don't think we need a walkthrough per se, but it would be helpful to, and this might be something you need to come back with, I don't know, to understand the differences between what's being struck and then what's being added so that we can actually see the language.
Okay.
That would be helpful. And if that's not something that we can do right here, we can do that next week. It's up to you.
I don't have the language that's being struck pulled up, but I pulled up the language, the addition on the, so you can see the actual language in the CFR.
Okay, well, that would be helpful if we could see that. Yeah, sure.
Oh, I wasn't even logged into Zoom. It's gonna take me a minute.
That's okay. And Zon.
Okay, I'm paying attention.
I know you're paying attention, you always do, but I'm just saying, tag you're it for reporting the bill.
I'll be asking 75 questions.
Sorry, I don't have the invite, the link in the invite.
Do you ever feel like all the eyes are staring at you?
Not Jill just now. Okay. So here is in Katie McLean, Office of Legislative Counsel. Here's an excerpt of the Code of Federal Regulation that is cited in your bill. So what we have is uses and disclosures for research purposes, permitted uses and disclosures. A covered entity may use or disclose protected health information for research regardless of the source of funding of the research, provided that first we have board approval of a waiver of authorization. The covered entity obtains documentation that an alteration to or waiver in whole or in part of the individual authorization required pursuant to another section for use or disclosure of protected health information has been approved by either an institutional review board established in accordance with federal regulation or a privacy board that has members with varying backgrounds and appropriate professional competency as necessary to review the effect of the research protocol on the individual's privacy rights and related interests.
Okay, so now I see that the references, there's several references to 46 CFR, which is the one that's being deleted. So I guess for our own clarification, wanted to make sure that we weren't really leaving out the definition that was previously contained in 46 CFR, and I see it's referenced in this as well, so cross-reference. So I think that's okay.
Okay.
Anybody have any questions about this? So this is the underlying piece to which the health department is asking to include here. A and B, and that's what we just looked at, okay? Okay, thank you, Katie. Does anybody have any questions for Katie in terms of, yeah, go ahead.
I simply, I'm sorry, I don't understand the definition of surveillance. Is that just like a review of data that's not being used to develop scientific thought or something?
I think we should ask the health department for
Okay.
that
I'm sorry.
definition.
What's that?
No, that's fine. That's, no apologies necessary. Surveillance has a very specific term in public
that
health.
world, yeah.
So, Lauren, if you can, help out the committee with that, that would be great.
Yes, so public health surveillance is defined under HIPAA and elsewhere, but it's surveillance or research conducted by for reporting of diseases or injuries, reporting vital events such as birth or death, and conducting surveillance means like awareness. So, okay, there's a certain number of diseases, there's a certain number of cancer incidents, there's a certain number of conditions of this genotype in this space. So we're surveilling the field of data that is provided to see if there's any patterns. And that helps investigations and interventions for diseases in certain areas.
So how does that differ than sort of the term research as used in this context?
It's conducted by a public health authority. So a public health authority is a specific type of entity. It's an agency or authority of the government, a state, a territory, that's responsible for public health matters. And it's official mandate. Or anybody acting under the authority of a grant or a contract with a public health.
Anything else, Representative Easties?
No, I think I
Okay,
get it.
thank you. Any other questions? Comments? Okay. Any other requests for testimony? Yes, go ahead.
I do have one question. The question was asked by Representative Donahue, or the point raised about some reservations, if that's phrasing it correctly, about the body that would review these requests. If we didn't utilize that, though, I'm wondering, what's the volume of requests that come in? And are there other means by which the requests could be reviewed if we didn't rely upon these review boards and the like?
So just to clarify, the group that's been kind of carved out as being, what was the word? Only as being less worried about protection because it's not identified, that's surveillance.
Really?
That's not, I think that's not my problem. My question is if there are things that are still required to have IRB review, whether the IRB review is robust enough. So maybe I'm not sure what size group, because for what is being requested in most of these cases, I think I would assume most of them are in that new category. But the ones that still need IRB review, that would mean that they have higher sensitivity. And so that would be the question in terms of numbers, I think.
Okay. So I guess the question is, with respect to those that would still require IRB review, how large of a pool of requests is that? And so if we have reservations about the IRB process, I'm trying to envision how else we may ensure the proper review.
We wouldn't.
Yeah.
There isn't another
Yeah.
readily available process.
Right.
It would be kind of an all or nothing.
Yeah.
Okay.
So while it's certainly a relevant point to bring up, we don't have something to substitute for it.
Gotcha. Okay.
So I think that we would, Katie, want to keep it in writing. First obtain from such state registries, agencies, or researchers written assurance is acceptable to the commissioner
Sounds good. Okay.
in both cases. Does anybody else have any other thoughts about any other modifications they'd like to see?
The other one isn't identical, so it doesn't have,
No, it's not identical.
do you want me to add something about in writing, or since it doesn't say that, just be.
It should say in writing.
Okay.
It says, second, in the case of researchers, I'm just flipping back and forth. Well, they're not asking for any changes in that one, so I'm presuming that they have written agreements. Provided access under such agreements is consistent.
Are you on page 4?
I'm at the bottom of page 3,
Oh,
before I get to the top of page 4.
okay.
When it's talking about the commissioner may enter into data sharing and protection agreements. I'm presuming that Lauren, that those, under the current definitions that people are looking at, that those would be in writing and signed.
Right now, yes, the data sharing and protection agreement, it would be in writing and signed. there isn't a similar complication with the CDC on that one, because
Okay.
the CDC doesn't have an ALS registry.
Okay, all right. Uh,
Sorry,
And evidence, the commissioner shall obtain evidence of approval. What is that evidence typically? What is that evidence typically?
usually a written statement signed off by the IRB or the privacy board. In this case, it would be a written document consistent with the HIPAA language that Katie just read.
Okay. Maybe we should just be clear and say written
Written evidence.
evidence
Yeah.
in both cases. As Lauren said, the world is changing, so
Yeah.
I think we need to keep things in writing. Okay, anybody else have any other suggestions? Okay, so then maybe we could see a draft next week.
Yes, with those two changes, do you want just the instances of amendment or do you want to see a strike all?
Oh, it's gonna be easier for Zon to report.
Tell me.
A strike all is probably gonna be easier for you to report. Then you don't have to refer back and forth to the underlying bill and the amendment.
I'll do that.
All right, thank you, Katie. Have a nice weekend.
Thank you as well.
All righty. So, folks, we'll schedule that for, a vote probably Wednesday morning, something like that. It won't take very long. Whatever. Or, yes, we will make it happen. It'll be quick,
Don, I'm healthy.
or whenever you can fit it in, Lauren. Okay, so next, yeah, I was just gonna, I don't have a draft. Lori, maybe you can tell us what we're doing next week.
Tuesday, Oversight and Accountability, Syringe Services Implementation of Act 22/2023.
That's a follow-up to,
Dougherty.
yeah, that's a follow-up to Representative White when she was here on syringe services.
And then after that, Disability Law Project, something to talk about H92. Then Wednesday morning, H92 with staff attorney for AHS. Those are the things that are confirmed.
Okay.
Then we move into the invited. Ashley Berliner, Director of Medicaid Policy, talking about the play therapy Medicaid bill. And I'm holding some time for people about S36. After floor, Katie's gonna start markup on H92.
Mhm.
Thursday, a bunch of testimony about S36. After floor, more markup on 92. And then after floor on Friday, markup and potential vote on 92.
Okay,
And then some other stuff in there, but not confirmed.
okay, and then, stick in
Yeah.
on 293, because we just did introduction to markup all in one. We were very efficient this
Yes,
afternoon.
yes, very good.
Okay, so we'll see you all on Tuesday. Have a great weekend. Thank you for being with us this afternoon.